very excited to welcome everybody here to this session on behalf of our Bishop, Dr. Roxanne Haynes, and on behalf of the Women's Ministry at Restoration Fellowship. I want to take this opportunity to welcome you all. And right off the bat, I see that the room is full, it's getting fuller, which tells me one thing. It tells me that you are all hungry to gain wisdom. And so we're going to get started. I'm going to open us up in prayer, and we're going to move right into our session for this morning. Let's just look to the Lord. Heavenly Father, we come to you right now, and we just want to say thank you for all that you are, for all that you have done for us. We thank you, Father, for waking us up this morning, that we have a mind that we can think, that we can process, a mind that we can receive wisdom from you today. God, we are just giving this session over to you, and we are saying thank you in advance for all that we're going to learn. Lord, we will not take this opportunity for granted. I thank you for every person that's here in this room. I thank you, Father, for all that are involved in the preparations. We thank you for our guest speaker. I pray, Father, that you will touch him and that you will bless him, bless all that are on this line today, Father. And I thank you that because your word says that your people perish because of a lack of knowledge. I thank you that today we have the opportunity to have that reversed. We have the opportunity, Lord, to sit at your feet through your vehicle, through your instrument, Lord. And so we say thank you, and we are now open for your instructions. We are now open for your movement in our lives, for change, for transformation, and to be able to live the life that you always promised, and that being abundant life. Lord, I thank you that in this hour, in this season, you are empowering your people. You are giving us tools to be able to advance and to be able to impact the kingdom for your sake. In Jesus' mighty name, we give you the honor, we give you the glory. We bless our bishop in the name of Jesus, and we bless every person on this line. Amen. Praise the Lord. Praise the Lord, everybody. So I want to share a scripture with you at this time. It's taken from Proverbs chapter 3, and it's verses 13 to 24. Blessed is the man who finds wisdom, the man who gains understanding, for she is more profitable than silver and yields better returns than gold. She is more precious than rubies. Nothing you desire can compare with her. Long life is in her right hand. In her left hand are riches and honor. I'm going to say that first again. Long life is in her right hand. In her left hand are riches and honor. Her ways are pleasant ways. All her paths are peace. She is a tree of life to those who embrace her. Those who lay hold of her will be blessed. By wisdom, the Lord laid the earth's foundations. By understanding, he set the heavens in place. By his knowledge, the deeps were divided, and the clouds let drop the dew. My son, preserve sound judgment and discernment. Do not let them out of your sight. They will be life for you, an ornament to grace your neck. Then you will go on your way in safety, and your foot will not stumble. When you lie down, you will not be afraid. And when you lie down, your sleep will be sweet. Amen.
Good morning, everyone, and welcome again to Restoration Fellowship's Wills and Estates Planning Session. We have been blessed with the opportunity today to hear from the industry's leading expert, Mr. Perry Trott. Mr. Trott is one of the founding partners of Trott & Duncan Law Firm. He is the director that heads Property and Estates Departments. His clientele includes both local and international clients, and he advises in all aspects of private client work. In particular, his expertise ranges from residential and commercial property transactions, estate planning, wills drafting, administration of local estates, and applications for probate in Bermuda. In 2016, Mr. Trott recognized that there was a knowledge gap in respect of the importance of estates planning in Bermuda. And based on this, Mr. Trott made it his team's mission to inform fellow Bermudians about estates planning through private presentations at various churches and organizations over the past 5 years. This has actually proven to be quite invaluable to our local community. Mr. Trott is as excited to hear from us as we are to hear from him. And so he has graciously allowed us a 30-minute Q&A session, which follows his presentation. What we're gonna do is to ask you to hold all your questions until the end. And then if you would like to submit them anonymously, please submit them to our Chief Technology Officer, Elder Selena Haynes. And if you don't mind sharing directly, then please virtually raise your hand on Zoom and we will call you in the order in which the hands are raised. So without further ado, I now hand it over to Mr. Trott. Mr. Trott.
Good morning, everyone. Bishop Haynes, Lisa, and Alexis, thank you very much for the introduction. Thank you very much for having me. Anytime I've been asked to make this type of a presentation, I never say no, because I'm very passionate about this aspect of the law, because it's an area I think everybody in Bermuda needs to know about. We already know about it, but the thing is, we don't like to face this area. And the area I'm talking about in the presentation is on estate planning. We generally don't like to talk about it because we always say, well, you know, I'm not ready to die. Because everyone says it's synonymous with, I'm going to die, so I don't want to talk about it. But once you understand it and you're very clear about it, it becomes another aspect of your life that you have to address. So the challenge I have is a challenge I have in all my presentations. That is to try and effectively communicate this topic to you so that you have that appetite to go out and explore it, get it done, and get that control and peace of mind. Throughout the presentation, you will hear me talk about control equals peace of mind. The reason being is I'm going to show you what happens when you have control, which equals peace of mind, and what happens when you don't have control, and that when you do not have an estate plan in place. Now, let me put these presentations in some form of context. If you can bear with me, I'm gonna put up a slide. Some of you may be offended. Some of you may flinch, but this is reality. So bear with me 1 second, and this will tell you why I'm doing these presentations. I'm a firm believer that if you have a problem in life, there's a solution. You may not like the solution, but there is a solution. For years now, I've been going back and forth to the hospital or to someone's bed. The reason being is that people call me at the last minute to do a will or power of attorney or some form of a estate planning document that they need done. And generally, I find these people either incapacitated or there's just no way that they can to give me firm instructions. I have been to the hospital in circumstances like this years ago, and there's nothing I can do. So the solution to this was that I said, about 6 years ago, I decided to assemble a team and to get out in the community to educate people as much as possible of why it's so important to have an estate plan in place. Initially, I must tell you that I could see there was some resistance, but I'm now realizing after doing something like 80-something presentations, people are now beginning to come in and get the stuff sorted out, particularly after the pandemic, where so many people were passing away. People began to think, people began to realize that it's important to have an estate plan in place. Now, there's a number of reasons, and I just pause to say this here. When I was growing up, and I'm sure most of you have heard this, the important things in life were getting married, having children, and buying your first home. I would like to make a fourth pillar, and that is estate planning, because the estate planning that you put in place should protect all those things there: your spouse, your children, and your assets. People don't think of it that way. So this is what I'm on a mission to do with my team, to try and educate people the importance of having estate planning in place. Now, as I said, throughout the presentation, you're going to hear me use these words: control equals peace of mind. Now, when I talk about an estate plan, I'm talking about three main components: a will, a power of attorney, and a living will, or what is otherwise known as a healthcare directive. I'll talk about other things, and we call these miscellaneous things like taxation, insurance, rest homes, things of that sort there. But my primary focus this morning will be on those three items. And again, it's all about having control. Now, people have a misconception of estate planning, by the way. They say, I don't have anything to leave. I'm too young to think about dying. If I plan now, then I will die soon after. And you can see the list there. Those are the primary list. But after doing these presentations for a while, I realized it's all about procrastination. People have to do it. They know they have to do it, but it's about procrastination. And sometimes, you say to someone, you have to do it. The very thing you say to them that they have to do, they don't want to do it. So we're finding ways to sort of gently nudge you along and say, yeah, you should think about doing it. And it's working, but we still have people with excuses. And these are all the excuses that I've heard over the years, and I've heard particularly in the last 6 years. I think they're up on your screen. I don't need to go through them. Some people say that we're too busy to plan our lives. Let the family fight over it after you're passed away. I think the funniest one for me, and it's not really funny, is I will say to a client, why don't you do your will now? And they will say, well, I'll do it after my birthday, party, summer vacation, medical procedures. Well, guess what? I've had instances where people have said that, and they've literally gone out and passed away without a will. What I'm saying is, I think we need to stop procrastinating when it comes to this here. And that's why we're out there. Now, I'm going to start with what is a will. And by the way, today is a more condensed version of my presentation because it's in the interest of time. This is a very vast topic. So I'm sure you must have a lot of questions, but as I said, once you've made your decision to make a will, please go in and see an attorney. And when I say what is a will, this is the legal definition of a will. It's a legal instrument that permits a person, the testator, to make decisions on how his or her estate will be managed and distributed after his or her death, and only takes effect upon death. If I was to put that into layman's terms, all it is a legal document that indicates how your assets should be distributed after your death. That's all it is. But it's a very powerful and most important document, because that's when I talk about the control. And again, I cannot emphasize the importance of that control. Now, why do you need a will? You need a will to preserve the value of your assets, provide for your family after your death, and it's also a way to avoid unnecessary legal costs and taxes. But again, the purpose is to keep control. I'll touch upon some of those items that I just spoke about. For example, avoiding unnecessary legal costs and taxes. I'll touch upon that shortly. But this is the primary reasons why you need to have a will in place. You want to provide for your family after your death. The contents of your will could be very wide. You can make provisions for guardians, for minor children. I have a lot of single clients who come in and they don't have any assets or major assets, but they do have children. So a will is a good way to appoint your guardians for minor children. You can leave monetary gifts, any special gifts. You can even indicate how your funeral wishes, whether or not you want to be buried or cremated. So there's quite a bit you can leave within a will. There's a few minor points that you need to take in consideration when you're doing your will. If you're contemplating marriage, please let your attorney know that because we have to draft the will in such a way. There are things such as mutual wills. This is excellent for married couples because let's say you want to leave the house to your 2 children. What a mutual will is an agreement between the husband and wife that if either one of them dies, the other agrees that that property must go to those children. It also makes provision, you also make provision for family disasters. So if there's a family of 4 and you go on a vacation and God forbid you all pass away, we need to make provision of what happens to your assets in the event that something like that should arise. A lot of people don't think about that. So these are just some of the miscellaneous points that we would have to consider. Again, I don't want to get into detail because of the interest of time. Now, once you've drawn up your will, you should put it in a safe place. We always suggest that you might want to leave with a law firm. Most law firms have a secure safe, and every 3 to 5 years, you should go in and review it. If you want to do minor amendments to your will, you can do it by way of a codicil. If you want to revoke your will and create a new one, you can do that as well. These documents are not etched in stone. 2 things I will point out to you here. Before you even go in to see your attorney about making a will, what you should do is do your investigations. There are about 590 something lawyers in Bermuda, but only very few of us practice in this area every day. The other thing you should consider is when you're doing your will and you ask whether or not there are any questionnaires, any documentation you can get beforehand, before the meeting, because it saves a lot of time and expense. The other thing you can do once you get those questionnaires is sit in a very quiet place and start to complete them. Once you've completed them, go in and see your attorney, and then the ball begins to, or the show begins to play out. Now, this is why at the beginning I've emphasized the reason why you need to retain control. If you do not have a will in place, you will lose control. What happens is that the law under the Succession Act of 1974 will determine who your beneficiaries are going to be. And I'll repeat that for you because this is why we have the strife and the problems we have in the island. For example, if you drive around and you see a derelict home, you do your investigation, it's generally infighting amongst family because there was no will in place. Again, if you do not do a will, the law will decide who your beneficiaries are. And so you lose control. And let me tell you how clinical this can be. All we do is, when you die without a will, we just go to the Succession Act and we look to see which case you fall into, whether it's case 1, case 2, case 3, and it goes on. I will give you an example of what case 1 looks like. Generally, you have a spouse, husband and wife, no children. The house is in the name of the wife. The wife passes away. You automatically assume that the husband will inherit that property. Not so. If the spouse who passed away has parents, then the parents will share in that asset with the husband. If there are no parents, then you look to see whether or not the wife had any siblings. If there are siblings, then they get to share in that house with the husband. It's only once we've gone through that exercise, if there's no parents, no siblings, then the entire estate passes to the spouse. Now, I'm omitted to tell you about, and I'm not going to get into detail. I tend to tell jokes. I tend to tell stories, real life stories. But again, in the interest of time, I'm giving you the clinical presentation of why it's important to get a will in place. Again, this is case 2. Husband, all the assets were in his name. He passed away. Again, you assume that the spouse is going to get everything. That's not how it works. If he dies in the absence of a will, and let's just say there's 2 children and the spouse will get half of his assets, or $100,000, whichever is greater, and the children will get the other half. Now, I will tell you this one story. When I returned to the island to start practicing years ago, one of my first cases was with a situation just like this here. So the wife and the 2 children inherited the house, but one of the children was living overseas. In fact, she was living in Miami and she was enjoying her life. She didn't want any part of the house. The mother wanted to live there because she's lived there for 38 years. And the other sister was now married and she had her children and a mortgage on her house. The daughter who lived in Miami decided, you know what? I want my interest. So either you buy me out or I will go to court and get an order for the entire house to be sold. Well, the house ended up being sold. She got her interest out, but the mother now lives with the daughter who's married and has a mortgage. Sad thing about this story was that the husband who was married to the daughter did not expect to be married and find that he had to support his mother-in-law. All because the husband never left a will. So control was lost there. I'm not going to go through any more examples, but I think you get the gist. And that's case 3, and it becomes complicated after that. Now, one of the reasons why I encourage people or emphasize you really do need to do a will is because when you look at the calculation of a stamp duty on an estate worth $1 million, you'll pay $85,000 in death tax. That's $85,000, that's a lot of money. And years ago, what used to happen is that families were forced to sell their homes because they needed to pay the death tax of $85,000. So the good thing is, in about 2005, the government of that day introduced what is called a primary family homestead certificate. And this is something else that's really important, and a lot of people don't know about it, but they need to take advantage of it now whilst it's in operation. If you own a home and you get this primary family homestead certificate, your state will pay no death tax on that one home that you designated as your primary homestead. This is an excellent mechanism. So let me give you an example of how I would minimize someone's estate as far as death tax is concerned. If, for example, you have a home that's worth $750,000 and you have $300,000 in cash, my advice would be simple. You go and get a primary family homestead certificate on the house so your state pays no death tax. You take $200,000 of your $300,000 and you put that in a foreign currency because death tax does not apply to foreign assets. And you keep $100,000 in a bank account. So you operate off that $100,000. Your state may end up paying nil in death tax, but you have to have the conversation, explain this to your lawyer. He has to have a full picture of what you're thinking so that his whole object is to minimize your death tax so there's more assets there for the beneficiaries. If you own more than one house, you might want to consider voluntary conveyance. And if you own a lot of assets, you might want to consider trust, but I don't want to get into detail on that one. But these are the ways in which you can minimize your death tax. And that's why it's important to go in and see an attorney and get a clear idea of what you need. Now that is a will. You've seen what happens when you have a will and what happens when you don't have a will. Now there's another component of your estate plan, and that is the enduring power of attorney. You have to ask yourself, who will take care of your financial assets if you lose your mental or physical capacity to do so yourself? It's not unusual for health issues to creep up on us. It could be cancer, it could be strokes, which is huge in our island, dementia's on the rise. There's so many illnesses out there. You don't know whether or not when they may strike. So it's always nice to be prepared to have what is called an enduring power of attorney in place. And as I said, it only takes effect when the doctor certifies that you're either physically or mentally incapacitated. In the absence of not having this, if, for example, you have a stroke, you're now up in Leahy or Johns Hopkins, your family needs to get into your bank accounts and conduct your financial affairs for you. If they don't have this in place, or you don't have this in place, they now need to go to the courts under the Mental Health Act to get an order that will allow them to conduct your affairs. Something like that can run you at least $2,000 to $3,000 in legal fees. But if you have this in place, that can run you anywhere between $700 to $1,000. You can do the math. So it's called an enduring power of attorney. The other component that you will need is what we call a living will or medical directive. This applies to your health. And all it is a written document that spells out the type of treatment and life-sustaining measures you want or do not want. And you designate an individual to make medical decisions for you in the event that you're unable to do so. It is important because when you're sitting there in front of a doctor with a stroke, you're not able to effectively communicate your concerns. This is where the designated person will be able to advocate on your behalf and be able to indicate what your wishes are. What you don't want is for your family to be fighting over your medical needs because the doctor is waiting for instructions. I personally, by the way, all these things that I'm talking about, they're from personal experiences as well. So for example, I had an accident. I had a hole in my leg. This is about in 2014. I had a hole in my leg and I had to be rushed to hospital. The good thing is I had my enduring power of attorney, my medical directive in place, my agent. She was able to get me through the process, back home safely in less than 2 hours. I call these, whoever you appoint should be somebody, as your agent, should be someone who is what I call a pit bull. They take full control. And they're able to give the doctors and the nurses and whoever the medical persons are, they're able to give them firm instructions of what your needs are. But the important thing is that you need to do, before you give out any of these, appoint an attorney, you have to talk to that person. The single most important thing that family and friends can do to prepare for the end of life, someone they love, you need to talk to the person that you've appointed. You let them know what your needs are, what you don't want, and what you want. Now, there's so much interest in living wills now because life expectancy is increasing at a rapid rate. And most individuals, most of my clients that come in, they want to avoid the confusion, undue stress placed upon the family members if there's a need to make decisions in relation to medical treatment and care. So I'm finding a lot more people wanting to put these type of documents in place. When you're selecting your agent, it's very important. Make sure they meet the legal criteria. Make sure they're willing to speak on your behalf and handle the responsibility, because it's extremely important. And not everybody wants to take on that responsibility. make sure they're able to act on your wishes, not on his or her own. This is your wishes. So this is why I say you have to effectively communicate what your wishes are. And they should know your values, priorities, and goals. That's a taken. But the most important thing I find in all these elements is that they listen and talk with you frankly and openly. And they're able to manage conflict among family and others. Sometimes you may very well appoint a neighbor or a cousin. That person must be willing to say to your children and your spouse, I'm sorry, but this is what she wants, and this is how we're going to do it. And they should be a strong advocate in the face of unresponsive doctors or institutions. That's important as well. And by the way, you're going to find that as you go overseas to get medical treatment, a lot of hospitals and doctors will ask for a healthcare directive to be in place because they need to know who they're going to take instructions from. As I said at the beginning, when you're sitting down and you're thinking, okay, who's going to be the executor of my will? And the executor is a person in your will. They are the ones who, at the time of your death, or after your death, sorry, they will collect in your assets. They will meet with the lawyer. They'll make sure the debts are paid off and the assets are, that your estate is probated and the assets are distributed in accordance with the terms of your will. When you're thinking about this, you sit down in a very quiet place and you set your goals. Who am I going to appoint as my executor? Who do I want to leave my assets to? Who do I want to appoint as my enduring power of attorney, my agent? Who do I want to appoint as my agent for my healthcare directive? And once you've got a clear understanding of what you want, then you do what I call as an action plan. You do your research and find out or find an attorney who specializes in this area, and you make contact with them. The reason why I said to you at the beginning and I say now is this. If you came to me about 20-something years ago and you said you wanted to do your will, I would have just drafted your will according to the terms that you've instructed me to do so. But 20 years later, I take a different approach because I've had more lifetime experiences, and that is, let us sit down and have the conversation. Let me hear the entire your concerns so that I might adequately give you the advice you need to minimize any strife after your passing. The big problem we have in this country is that so many people pass without leaving a will, for example, that when the families come in, you can see that they're emotionally driven because they're really fighting over stuff. And so my thing is to ensure that you have a very tight will in place, not only to minimize death tax, but it's to minimize strife. So I might get a client who comes in and say, listen, I'm not leaving any assets to this particular child because of X, Y, and Z. Well, I need to know that because I need to draft the will in accordance to your instructions, but more importantly, to ensure that it's not challenged upon your death. But I also go a step further and I ask you to consider writing a letter to that person, explaining why you've made that decision. And let's put that with your will. And I can pass that to the person upon your death. Now that's a good way to minimize strife because you at least have a finite, or you leave that person with a finite reason as to why they did not inherit any assets. And it could be various reasons. Why? Because I paid for your education. I gave you your first down payment for your home. I've also supported your family this way and what have you. So I think I've given you enough during my lifetime. But I encourage you to write the letter. And so this is why when I meet with you, I need to know the full story. Now, once you've met with the lawyer and they've drawn up the documents and what have you, the next stage obviously is to review it every 3 to 5 years. Circumstances change. You have grandchildren, you have children, you have godchildren. Circumstances change and you need to review it. So you just go into the lawyer's office every 3 to 5 years and you review it. And if there's any minor changes, as I said, you can do a codicil If there are major changes, then you may have to consider drafting a whole new document. So I've talked to you about a will, talked to you about an enduring power of attorney, and I've talked to you about a healthcare directive. Those are the main elements of your estate plan. But there's some other things that you should consider as well. You should consider, for example, meeting with a financial planner and investment advisor. I find that they're an excellent component of your estate plan because they will indicate to you how much money you're going to need to retire, how much money you're going to need if you want to achieve certain assets that you want to leave for your family. They're an excellent resource. There's some miscellaneous points that I also ask that you consider, which is rest terms and financial assistance. I know some of us are a little bit farther away from that, but you'll be surprised how life creeps up on you very quickly. So these are things that you should consider. If you're dying overseas, whether or not you want your body to be returned to Bermuda or whether or not you want to be cremated. I give the example, if you die in Russia, to get your body back in Bermuda, it's going to take quite a bit of time and quite a bit of money. So you might want to consider whether you want to be cremated, but that's your call. I also ask that you consider your funeral expenses. Most people years ago passed and the families would step up and pay, but a lot of families are not doing that as much as they used to years ago. So you might want to take out what they call peace of mind insurance. You can check with the insurance companies on that. Or as some of my clients do, they attend the funeral homes now and they make a down payment and they just keep paying on their funeral expenses. It is very important that you preserve and know the location of your personal documents. And when I say personal documents, I mean your deeds to your property, your insurance policies, the whole list. Is extremely important that you keep them in a very safe place. The other thing I want to point out to you is that, and this is just side notes, I do home visits, but they're generally for people who they just can't get out. They just cannot get to the office. I will go out and meet with them and work with them. They could be physically challenged or they just cannot make it into the office. Generally, I leave that for seniors. I don't call them seniors really. In my presentations, I call them mature adults with a lot of wisdom. But I do have a very soft spot. So I do have situations where clients will come in and they will say, listen, I don't have all the money to pay you, but I need you to work with me on this here. I work with them. And let me tell you why I work with them. These presentations I do are free, yes, but it's twofold. One, I need to educate the community about the need and the importance of it. But it's our way of giving back to the community because it's the community that made Trott & Duncan what it is today. And so this is one of the ways that we give back. And when it comes to seniors in the community, we tend to zero in on them because there's a need there. So as I said, I will do home visits and I do give private presentations, but they are for 10 people or more. That I just talked about. There is a book that I have written and it's going to be dropping soon. I think that's the words that my publisher keeps using. And in that book, and I would like for you to remember it, like for you to even go out and buy it actually, it's called Let the Drama Begin. In that book is based on, it has all the questions and all the answers there that I've experienced over the last 6 years. So people may ask me, what is a will? Can my executor do this here? What is an enduring power of attorney? I explain all that in the book. But I also, what makes the book so interesting, I bring it to life because I tell you stories in that. And those are real life stories. There's about 18 stories in that. You may find them interesting. The titles in themselves are very interesting. For example, I have the man and his mistress, the father who's not my father. I have the fighting sisters. There's a whole list of them. And the true stories that have happened in my experience and to some of my clients. And they illustrate the importance of ensuring that you address your estate plan. So please look out for the book. I'm hoping that it will drop this month, but it's going to be within the next 6 weeks. And the title of the book, as I said, is Let the Drama Begin. So I pretty much covered, and I'm leaving it open for questions, but there's something else that I do as well. There's another request that I make because, as I said, I do these because I'm passionate about them, but life is an ever-changing balancing act. And sometimes you need a little help stacking it in your favor. The reason why I have that up there is this. Our community has gotten to the point where we all need help. And so is the economy. So my thing every morning I get up and my prayer is, if there's somebody out there that I can help in any way, I ask God to guide me to that person to assist. Reason why I do that is because if I help one person and that person helps somebody else, then hopefully it will reverberate throughout the community and we end up helping everybody. Everybody gets help. So if it starts with one person and it just moves on, then I encourage people to try and help as many people as possible during the course of the day. And given the state of the economy, I don't think my request is too harsh. So that's the other thing I ask of those who listen. Please help others along the way. Ladies and gentlemen, that is my presentation. And I'm opening the floor now for questions. I didn't go into detail because I'm sure you must have a lot of questions.
Thank you very much, Mr. Trott. We've actually received one question so far. And that question is, can an attorney in Bermuda do estate planning for someone who lives overseas, or should it be an attorney in your city or state?
Yeah, I would, if you have assets in Bermuda, it's fine to do it in Bermuda. To do a will in Bermuda, you must make reference to the assets that you have overseas as well, because once you pass away, we would probate the assets you have in Bermuda, but we would have to send, but the country in which you have the other assets would probate your estate there as well. So if you have assets here, fine to make a will, but if the bulk of your assets are overseas, you might well be advised to create a will overseas.
Thank you.
And I'll give you by way of an example. In France, for example, they would prefer that they're French citizens, or if they have assets, or anyone has assets in there, that the will should be done or drawn up in France.
Okay, we received another question in the chat. Oh, it disappeared. Let me just get it in.
Okay, so I see a question here in the chat. I don't know if you can see, but I can't see the end of it.
Yeah, two of them came in via the chat, so let me just.
Right.
So the first one was, do you have to hire a lawyer to do your will here in Bermuda? Companies such as LegalZoom in the USA make it sound so easy to do your own will without hiring a lawyer.
I personally would not encourage anyone to go out and get these, what they call off-the-shelf wills. I had a client who had an off-the-shelf will, and she came in to see me, and she brought it into me, and she said, "Can you have a look at it for me?" In that off-the-shelf will, she appointed her husband as the executor, husband as the beneficiary, and she had her husband witness the will. Had she not come in and seen me and she passed away, that will would have been void because her husband, who's also a beneficiary, could not witness the will. There are a lot of reasons, a lot of things I've seen over the years that if you do not pay particular attention to those wills, they can be held to be void. So my view is that you should go in and see an attorney. Take advantage of it. You'll be surprised the information that comes out of there. Sometimes I sit down with clients and they say, oh, well, I didn't know this. I didn't know I can do this here. And I say, yes, these are things you can do. And so the benefit of having legal experience is something that I would encourage.
I second that. I am going to invite Roxanne to ask her question. I see that her hand is raised, so you can unmute your mic and go ahead and ask your question.
Good morning, everyone. I don't have a particular question, but I can speak to what Mr. Trott spoke about in reference to procrastination, as most of us don't want to think about dying. In recent experience, the person in my life that did not have a will or enduring power of attorney, there was some issues in us trying to get a letter from the doctors. It appeared that doctors don't want to commit to anything like that, depending on the state that the person is in. And it makes it very difficult. And especially if it's something that's not expected and the time happens, it just goes so quickly. So I'm just enforcing what Mr. Trott mentioned in reference to planning now, doing everything now while you are of sane mind and you can actually make the decisions that you want made. That's basically what I wanted to speak about.
And I'm glad you said that because that's the issue I'm having right now. I'm getting too many people come into the office at the last minute to get a power of attorney done. And when you say to them, there's really nothing I can do. If you come in and see me and you say, listen, I need to get a power of attorney done, or if you come in, let's just say you're in your 70s and you come in to see me. One of the first things I do is I test you. I'm testing you. I will ask you questions at the beginning. Particularly if I know you, I will discuss things and crack jokes and whatever at the beginning. And then in the middle, if I'll go and ask you those questions again and you can't answer them, then that's an indication to me something's not right here. So then the next thing I say is, I think you need to go get a letter from your doctor because I need to make sure that you're of sound mind to be able to give instructions. Well, the thing is, they go and see the doctor and the letter comes back saying that person's not of sound mind. Then I have to have the task of looking at the family and say, there's nothing I can do. We have to go to court. You can see the problems. You can see the anxiety on the face. So it's rightly so. You should get it done as soon as possible. And that's why I'm out here. And I think most of you appreciate coming from the church that it's all about getting your house in order. It's all about maintaining your house. The older I get, I appreciate it more. As a young person, I was told, make up my bed, keep clean clothes on, et cetera, et cetera. What that really is at the end of the day is just keeping your house in order. You never know. You never know what situations may arise. And it's just nice to have the comfort of knowing that those documents are there to protect you, but more importantly, to protect your family.
Thanks, Mr. Trott. So you have quite a number of questions coming in anonymously and in the chat. So we're gonna just start off and we can just run through this. So the first of these is, what do you suggest if you own two properties, one with a parent and the other with the spouse? If we designate one house as the homestead, how can we limit death taxes on the other?
Okay, so what you would do is you look at which house that you have an interest in, you determine which one is the most expensive one. And you get that house. You have to get a certificate for that, primary homestead certificate. Primary homestead certificates are personal to you. So for example, if you and I own a house together, we each need to go and get a primary homestead certificate, because we don't know who's going to die first. But the fact is, you both have to get a primary homestead certificate. In a case like that, it's generally, where you're married to your husband, generally you find that property is jointly owned. Generally, what that means, if your husband passes before you, then that house will go to you outright. On your parents' house, you might want to consider doing the primary homestead on that house, so that you pay no death tax on that particular house.
Thanks, Mr. Trott. So our next question is, I would like to get more clarity on the last man standing in a will.
In the sense of?
Well, it was received anonymously, so I'm not able to elaborate. That was what was received.
Yeah, I would need clarification on that point. Last man standing in a will.
Could the person who submitted that, could the person who submitted that question anonymously to Selena just provide us with some more information, and we'll move on to the next question while we wait for that to come in. So the next question is, how much does it cost to prepare a will?
I always get that question. It depends on where you go, what law firm you go to. Some law firms, for example, will charge by the hour. Some will charge a set amount. In our cases, we charge a set amount, and it can run you anywhere between $675 and $875. The reason why we do that is because we found that most people, they have a house, some money, and a few other assets. That's a very simple will. Obviously, if you've got a lot of assets to leave, it's going to be a little bit costly, but on average, it should cost you anywhere between $675 and $875 to do a will.
Okay, thank you. Does the person you choose to act on your power of attorney or in your living will / medical directive have to be the same person?
No, not at all. In all three documents, you may determine, as far as your executor of your will is concerned, it should be someone who is dispassionate. In other words, they're not going to take in consideration and they're not going to be driven by emotion. They're going to clinically ensure that the terms of your will is carried out. With respect to your power of attorney, it could be someone else. This is someone who's generally financially savvy, who will be able to protect your financial interests, be able to pay off your mortgage or pay your mortgage each month whilst you're rehabilitating. It could be someone who doesn't necessarily have to be an accountant, but someone who is financially savvy. With your healthcare directive now, it has to be somebody who, you can appoint anyone, but it really should be somebody who will want to take on that role, because that's a very difficult role. You have to sit down with the person and explain to them what your needs are, what it is that you don't want, and what you want while you're incapacitated. So they can be different people. And by the way, I find that in choosing those people, that's what takes up most of the time. You sit down and you say to yourself, well, I want to appoint my best friend as my executor, but she's kind of weak. She's not going to, I can't see her being strong enough to fight my children, because they're fighting amongst themselves as it is. So you spend literally 20 minutes, maybe 30 minutes trying to figure out who your executor is going to be. That's from my experience, has been the hardest decision that clients have had to make. Once you've appointed these people, it's important for you to go in and have a conversation with them, because some people don't want to be executors, or they may not want to be your agent for your enduring power of attorney, but you need to have that conversation with them. And one last thing I would say to you is that always think about alternates. So for example, if I appoint my brother as my executor, then I need an alternate. In the event he's unable or unwilling to carry it out, who else is there? Same way with beneficiaries in a will. Think of alternates. I want to leave my assets to my children, but in the event they predecease me, which is not unusual in Bermuda, who gets my assets. I have a family situation where, or I had a client situation where it was the husband, wife, and 2 boys. Both boys passed away. They predeceased their parents. So I always ask for alternates. This is why I say to you, if you came to me 20 years ago, I would have done it one way, but life experiences have taught me that no, we need to go a step further.
Thank you. Our next question is, if you have property overseas, what laws determine how the property is handled? Can a Bermuda court make such determinations?
No, this is a great way. You need to leave a will. In that will, you need to determine how the property is going to be distributed. Bermuda can enforce overseas. They can go into a foreign overseas jurisdiction to make a judgment on it. That's for the foreign jurisdiction to do that. But if you have a will, you can always take that will over to that jurisdiction and have it probated there, depending on the jurisdiction.
Okay. Our next question is, does a will expire or become void after a number of years if you don't see the attorney every 3 to 5 years, or don't update it when you have a change in status, such as marriage or divorce?
Right. No, a will doesn't terminate, and I use the word terminate, but the word is revoked or what have you. A will can stays in place as long as you want it to. But the reason why I emphasize that you need to go in and review it because circumstances change. I have a situation, for example, where the lady did her will in 2007. No, it's 2008, she did her will. And subsequently, her and her husband got a divorce, but in her will, she left everything to her late husband. To her husband, sorry. Then she passed away. Her husband was the only beneficiary. There is a law in Bermuda that says that once you get a divorce, that spouse that you have in your will, they are automatically carved out of your will by virtue of the law. So now we have a will, we don't have any beneficiary. Her only beneficiary was her ex-husband. So now what happens is that will becomes void and the law decides what happens to her assets. So this is why it's very important to go back and look at your will and review it. And in the same voice I say that, I also say to you, when you name beneficiaries in your pension or your insurance policy or whatever, go back and review it. I am so surprised about the number of people come in and they say, I don't know, even though it's on my pension, I got to go back and have a look. Or it's only when I raise it that they realize that the beneficiaries on the pension are the very ones they don't want there anymore. So this is why I say every 3 to 5 years, it doesn't hurt to review your documents.
Thank you. The next question is, when there are multiple homeowners / family members on a home, what's your experiences or challenges with putting a will in place? And how do we go about this process for all involved?
Okay, so it depends on how the property is owned, but it really doesn't matter at the end of the day. Everybody whose name's on that property should do a will. So for example, if you, and I don't want to complicate it, but in Bermuda, you generally own property in 2 ways. There's what we call joint tenant. That's usually between a husband and wife, which basically says it's survivorship. So if the wife passes, the house automatically will go, by operational law, will go to the husband. I still think you should do a will because you need to determine what happens if both of you pass at the same time. Then there's another way to own property in Bermuda, and we call it tenants in common, which means that each person has an interest in that property. So if you've got 5 children owning that property as tenants in common, each one of them needs to do a will because they need to determine where their share is going to go upon their death. Now, I would tell you all that when you sit down to do your wills, consider, if you've got 5 children, consider whether or not it's probably in your best interest to ask or your wish should be that the property be sold upon your death and the proceeds distributed equally amongst the children. And if there's a child, for example, that really wants the house and can get a mortgage or loan to do so, they can buy the house at 10% below the market value. I raise that because there are creative things you can do. The reason why I would suggest that is because when you leave the property to 5 children, you run the risk that they may very well fight amongst themselves. It gets very nasty. It increases the strife within the family, and somebody's going to go to court to try and get the property sold anyway, because they may want the 1/5 interest out. So again, when I'm advising you as to how you draw up your will, consider minimizing the strife that you leave.
Okay, thank you for that.
Yeah.
Our next question is, where do you go to get the primary homestead certificate?
I'd like to think they come to a law firm. You can go up to the tax commissioner's office and get an application. There is, some people find it, I say that lightly, but some people find it very, very cumbersome because they ask for a series of information. For example, they want to have the deed showing ownership for the last 20 years. They ask for a number of pieces of information. Some people get irritated by the process. They say, no, I'm not going to do this here. You can come to us in a law firm and we can do it. Or you can go up there and get the forms and take a stab at it. But either way, it's imperative you get it done. And this is why I'm recommending you get it done, because I'm a firm believer is that if something comes to you and it's free and there's no problem with it, take it. This primary homestead certificate, at some point, may very well, the government may very well decide, you know what, on that $1 million, we've just lost $85,000 in our, in terms of stamp duty. So they may decide to no longer proceed with primary homestead certificates. If you've already got one, then you should be safe. But at some point, the law may very well change. So this is why I'm recommending people, as soon as you can, go and get the application. If you're not sure about it, you're welcome to call my office and one of the administrators will guide you. But it's something that everyone who owns a home or has an interest in a home should apply for it.
Okay. It looks like we have about 3 more questions left.
Okay.
So the next one is, can you have more than one executor?
Oh yeah, of course. But the max you should consider having is 4. Most people, what they do, most people, so as to ensure a smooth probate, what they tend to do in the wills, they tend to appoint one person and then have an alternate of one person. Or they may appoint 2 people and then have one person as an alternate. So those 2 people will act jointly. And if for any reason one of them or both of them cannot, are unwilling or unable to, then the 3rd person will kick in.
Okay. We actually we have a hand raised and we have a last minute question that came in.
Okay, all right.
And then that'll be it.
All right.
So our next one in the sequence of the order received is, how would you suggest planning with or for young adult children who have turned 18 and or university students, since they're no longer a minor? A difficult conversation for seasoned adults, so likely a non-factor for them. Any tips on how to even start the conversation with them and this planning process?
Well, it's like, for example, people come in to me and they say, we want to put our children on the deeds, and the children are 18, 20, 21. What I always suggest to clients is put a stipulation in that says that you want to leave the property to the children once they reach the age of 25 years. That's a good time. 25 years is a nice balance. So you have to find a lot of clients that come in and say, you know what, my children are young, they're 18. I want to see how they develop and what have you. I'm going to leave this property in trust for them, or leave it with the trustees until they reach, and give it to them when they reach the age of 25 years. That's a very simple way to do it. And you can always, as I said, make changes to your will. So if they reach the age of 25 and you find them irresponsible, then you can revisit your will and redraft it. But I wouldn't be too quick to have conversations. You see, your will is personal to you. And when you go in to see your lawyer and you tell them the circumstances, they can craft a will in such a way to give you that protection that you're looking for as it relates to the children.
Okay. So our next question is a little bit of a scenario. If you own a property with parents and you're married, but your spouse's name isn't on the property, when contemplating the death of a parent or both parents, can the parents write a will for their part of the property to go to the spouse?
It depends on how the property is held. They can do a will, yes. But if it's joint tenants, it depends on which one of them passes first, which parent passes first. So if the parents own the house and it's joint tenant, then the spouse who passes, the surviving spouse, would have that property outright. So I'm not sure if you understand it, if you understand the answer.
I do.
Okay.
From a property law perspective, but I'm not sure as a layman if the anonymously submitted question is understood.
Okay. So, well, Alexis, do me a favor, repeat the question so that I can break it down for the person.
Okay. So if you own a property with your parents and you're married, but your spouse's name isn't on the property, so the spouse doesn't own it, in the event of a death of a parent or parents, can they write a will for their part of their property to go to the spouse whose name?
Yes, if both parents are passed, that would leave the wife as the sole owner, so she can leave a will determining how the property should be distributed.
I think the question contemplates the parents leaving a will so that their part of the property, their interest, will go to the spouse.
Yeah, they can do that. Yes, they can do that. Yes, they can do that.
Okay.
But as I said, if it's joint tenant now, and the daughter owns it as joint tenant with the parents, then as the parents can leave a will, they can do anything they want, but the law will dictate that whoever survives. So if both parents pass, then the daughter gets the property outright,
right,
irrespective of the fact that the parents have left a will that their portion go to the husband. So it depends on how the property is held. So if it's joint tenant, then whoever survives, so if the wife who survives, well, then she owns the property outright, and she can make a determination thereafter.
So in that scenario, we will probably suggest that the wife probably take legal advice to see how the property is held, so we can determine her next steps to understand about how the parents can write their will. That's correct.
That is correct.
Okay. We'll now allow Sister Laverne, who has her hand raised, to ask her question. If you can unmute your mic and go ahead.
Hello, yes, this isn't actually a question. This is something that I heard him bring up, and I wanted to draw attention to this. You mentioned people should also take a look at their pensions.
Yes.
Yes. One of the things that I found out recently, I had my pension going to my husband and my 2 children. And my husband passed, and I called the pension place and said, I just want to take my husband's name off and just leave it to my children. They said I had to do it in writing, because I want people to understand that if you don't take off the person who's passed, that won't automatically go to the 2 surviving. it would have to be probated. The portion that has the deceased person's name on it will need to be probated. And
Absolutely.
I just want to make sure everyone knows that, because I worked in the state for over 30 years, and I personally didn't even know that. So I wanted to make sure that I let people know that if someone passes who you left money to from pension, make sure you go to the company and have their name taken off, so that you avoid having to pay stamp duty on that portion for your children to receive at your death. Okay. Thank you.
That's vital. I can tell you so many stories of people who have gone in, and when they've reviewed the pension, when they look at the beneficiaries, they are surprised that they had made those decisions 20 years ago, and 20 years later, it's only at my encouragement they go in and look at it, and they realize that's not the persons that they want to benefit in that pension. So yes, piggybacking on what the lady just said, please review your pension and your insurance and whatever else. It's imperative. One of the things that I put in this book is a checklist. That checklist will tell you all the things you need to consider as far as your estate plan is concerned. And as I said to you, it's rest homes, checking your pension. It's a whole checklist. And so I would encourage you to go ahead and buy the book when it drops. Again, it's called Let the Drama Begin. My next bunch of sessions, I'm on the radio again. And I'm also going to be on television shortly as well, promoting the book. So please look out for it. And it answers all the questions that you'll be surprised that people have asked along the way. And so I've tried to encapsulate that in the book.
Okay, I'm going to read off the last two questions that I have, but we're not going to be taking any additional questions after this. So you can, if you have any additional questions, then you can contact Mr. Trott at his law firm. So first, we're going to go with a question about the homestead certificate. The question is, can you get a primary homestead certificate on a house that is not fully paid off, i.e. the deeds are being held with the bank?
Yes, you can. That's a straightforward answer. Yes, you can. What you would do is, as I said, one of the things that they ask for is a deed showing at least 20 years ownership. You would just call the bank and the bank will provide you with a copy. But yes, in answer to that question, yes, you can.
Okay. What happens when property is left to elderly children who are dying off?
Have they got the property, or is it just in the will?
Can Gail clarify? If you can open up your mic, we see that it was sent to the chat. So if you can just clarify.
Yes. Sorry. Okay. Basically, the property was left. There was an executor, right? Well, there were two executors. One died. There's still one alive, and the children was left to the children. The children are now elderly. I mean, it's a family homestead. It's been in the property for years. There's no mortgage or anything. It's just homestead, and the elderly children are dying off. One of the children lives in the house, and I'm just trying to ask as to how is that type of property handled.
Well, let me ask you a quick question. Was there a will in place?
Well, I think the will left it to the children. It was just like to the children.
All right. So this is the issue that we have. It's a problem in Bermuda. Okay. So as the children, depending on how that will is drafted, if it's just going to the children and in equal shares, for example, as those children pass away, you have to probate their estate for the one interest to determine who that one interest is going to go to. So let's just say it's just generally, let's say it's 5 children and mom, Daddy has left the property to those 5 children. If you don't probate the estate as quickly as possible after your father's passing, then it just languishes. And as those children pass off one at a time, then you have to go and probate their estate. And this is the reason why I'm trying so desperately to get people to do the wills, but also in those wills, if they're going to leave it to the 5 children, put a clause in there that says that in the event either one of them should die off, their share should accrue to the other remaining 4. If that clause is not in there, it means I've got to go out and probate each one of those people's estate in order to get clear title to the property. And I have had an experience. It took me 7 years to probate an estate because I had to go out to places like England, the United States. I had to put adverts in the newspapers, social media, etc., trying to find these beneficiaries. And it took us 7 years.
Wow.
So in answer to your question, in the absence of that clause being in there, then it means that as those people die off, we have to go and probate their estate so that we can get clear title to the property. And that's why if you're a beneficiary under will and the executors are dragging their feet to probate an estate, then you may want to take over and say, you know what, either you probate the estate or we're going to go to court. Because the longer a state languishes like that, it leaves it open for more problems in the future. And again, this is how we increase strife in the family, because people are going to start fighting over the assets because the next generation is going to come along and say, well, what's going on here?
Mm-hmm.
Yeah.
Okay.
Thank you.
I would like to be fair to 2 people who had follow-up questions that we missed. So the first one was a connected question to the what if the house isn't fully paid, about the getting the homestead certificate.
Yeah.
The follow-up question to that was, what if you own the house for just about a year?
Doesn't matter. Doesn't matter. If your name is on the deed, you're entitled to apply for a primary homestead certificate. That's the test.
Okay. Then someone who asked a question about 20 minutes ago, they actually asked who needs to be present when you are going through the power of attorney process?
Who needs to be present? I'm not sure what she means, but I can say this here, that whoever's been appointed as the agent is the person who will carry out the functions of a power of attorney. But when you're drawing up a power of attorney, no one has to be present, just it's between you and your attorney. If you want someone present as you give instructions to draw up the power of attorney, then that person can be there.
Okay.
I think
I'm hoping that person understood. It was an anonymous question, but I think it's
right.
Straightforward. Yeah.
Yeah.
Yeah. Okay. So our last question, and I might need some clarification from the person who submitted it. It says, can you explain how properties are passed down generation and how stirrups come into play?
Oh, stripes. Yeah, she says stirrups. No, you know something? That's an old phrase, by the way. But what I'm finding nowadays is that clients are coming in and they're saying, we just want to, what we want to do is to just sell the home or give the home to the children outright, and that's it. That's a very old approach to drafting wills. You don't see that too much. And if you want to make provision, for example, someone who is physically or mentally challenged, you can create a trust within a will for the duration of that person's life. And then thereafter, the property will go to the appointed beneficiaries. That's a way to keep the property, to make provisions for children like that. But generally what you find is people are just making finite decisions now, because it's a way of minimizing any strife within the family.
Okay. So I hope that answers the anonymous submission. Mr. Trott, just before I hand it back to Elder Lisa, I'd just like to thank you for sharing with us today and taking the time to inform us about these very essential issues. And I know based on the amount of questions that came in, there's a lot of heads turning and things ticking in people's head. And so I encourage everyone to not just remain at the stage of curiosity, but move to a state of action and, contact Mr. Trott. He seems very reasonable. I do know, I can speak from experience about the cost, the varying costs of this type of thing. And I know that there are some law firms that charge hourly, very expensive rates. And I was quite impressed by the price that you quoted for drafting a will. I think that's a very fair option. And I do encourage you to solicit his services if you are interested in moving forward with drafting a will. And buy his book.
Yes, I was.
I
was leaving that to last.
Yes. If you can keep us informed, we can remind everyone.
I will.
Of when it comes out, is definitely an essential tool that we have for life planning for someone as young as me or the oldest person on here. Like, it's invaluable to everyone. So we do encourage you to solicit Mr. Trott's services and get his book. And we thank you very much for taking the time and, carefully answering our questions and to bringing to light these very important issues that we kind of brush over on an everyday basis.
Right. There's other thing I ask is that if you like what you heard, please pass it on. Like I said, if we can get the information out there to the community, we can put people in a very better state of mind where they have that control and peace of mind. Yeah.
Agreed.
I thank you. I thank you for having me. I appreciate that.
Thanks, Mr. Trott. Lisa, will give you back the floor.
Thank you. Thank you so much, Mr. Trott. Awesome presentation. Thank you so much for giving up your time this morning, this Saturday morning. You could have been doing so many other things, I know. And I just, really want you to know that we truly appreciate you and all of the hard work that you've been doing. If you can tell that this is truly one of your passions, a passionate topic, as it affects all of us. And it's surprising to me that, this topic really resonates with so many of us on a deep level. And you brought that out. You brought that out so clearly today. And as Alexis has stated, the key now for everyone here on the line is to take action. It's not enough just to be receivers of great knowledge like this. But as I started out early in the session, it's all about wisdom. And with wisdom, we get the tools and we can apply them to our lives. And there are so many ways in which everybody here on the line can apply this information. So applicable to today and where we're at. Lots of things that I wasn't aware of, even though I did hear you on one of the radio sessions. That's one of the reasons why when I got off of that radio interview, I was just pumped right up and I said, this is the topic that the women's ministry over which I lead, we need to tackle, we need to get this topic to the people. So thank you so much. Thank you to everyone here on this line. I want to commend you all for getting up early on a Saturday morning to come and listen to a topic such as this, but I know that you feel well rewarded and that it was well worth your time. And I want to thank all of the team, all the team members of the women's ministry, and in particular our media team. I want to thank Elder Selena, our media person, for getting this set up. I want to give a special thank you to Alexis, our moderator, for doing such a great and fantastic job here this morning. So we want to let you know, everyone, that yes, this session is recorded and it will be available on the following formats. It will be on our Facebook channel, on our YouTube channel, and it's also going to be on our website, directly on our website. Okay, so feel free to go back. I know that with a topic like this, as Mr. Trott said, we're going to really need to take some time, quiet time, and really review the information, think about how it's going to apply, and really ask ourselves some very important, critical questions about ourselves and about how we want to see our future with our estate planning. So on behalf of our bishop, I believe she may be still on the line, I'm not sure. I just want to wrap it up and say thank you once again to everyone. If you have further questions, as Alexis has stated, feel free to contact Mr. Trott. And we're going to be sure that Restoration Fellowship, at least I can say for sure about Restoration Fellowship, we will be purchasing your book, Mr. Trott, because we are a ministry on this island that truly believes and supports people like yourself, because we recognize that God is speaking to us in so many ways. And sometimes it's not clearly as obvious that we would take, so many times we take for granted that there are tools and instruments that he is making available. And so thank you for you making yourself available so that we can learn. And I heard you say in your presentation that you always are looking for ways to help someone. And we're going to definitely carry that on, carry the torch, and we're going to carry that out.
I appreciate that. Yes. Thank you very much.
Elder Lisa, we just received a request for Mr. Trott. Are you able to share your contact details for the listeners and attendees?
Yeah. Before I do that, can I take a latitude on something very quickly?
Sure.
Okay. So let me explain something to you as well, why I'm motivated by this here. As you know, death does not discriminate. You never know when it's going to happen. And so the reality is that you always have to be prepared. I will drive these 2 points home because I believe some of you will know these women when I mention them, and they're dear to me. Is last year, August, I was away, and I got a call saying that my business partner passed away. Her name, as some of you will know, is Karen Williams Smith. She was a matrimonial attorney here. And I thought, well, she's only 52 years old. It makes you think. But then 9 months later, I'm also again on vacation. It seems like vacations are fit for some reason out there. I get a call telling me that my receptionist of 22 years passed away. Her name was Florette Gibbons Nash. And so that makes me even more, that's sort of giving me that reinvigorated me or renewed my call to get out there and really push this topic, because you just never know what's going to happen. And so I'm just giving by way of example those two to show you why it's important for you to stop immediately, give this some thought and act on it. And so just piggybacking on what Lisa said, it is really something that you just really have to sit down and think about it. Mm-hmm. So again, I thank you for the opportunity, and Lisa, and contact me. I appreciate that. And Alexis, thank you very much. And also to the bishop as well. And all of you who have heard it today, I truly hope that you act on it. Make sure you enjoy your day and be safe.
Thank you so much.
Don't forget your contact details, if you can share your number. And
it's okay. So my email address is ptrott@td.bm.
Okay, I'll just go ahead and drop it in the group. Yeah.
Okay, and my telephone number is 295-7444.
Great.
Okay.
So we're expecting your phone to be ringing off the hook and your inbox to be quite full.
But to be honest, Alexis, you've already started sending emails, so I've received them.
All right.
All right.
That's good
Thank
news.
you very much.
Taking action.
All right.
God bless
Bye-bye.
everyone. Have a wonderful day. And if you would like to join us on our Sunday morning service, you're welcome to come along. We are in person at the BUEI on Sunday morning. That's this Sunday morning, tomorrow. God bless you all.